Number 146, the matter of Jamal S. Counsel?
Good afternoon. Tahira Sadria appearing on behalf of the Presentment Agency. The Presentment Agency would like to reserve 3 minutes for rebuttal.
3 minutes?
Yes, please.
Okay, try to keep your voice up.
Thank you. The question here is whether the police may ask a juvenile who is lawfully in custody to tap out his shoes as part of a standard safety procedure, which included the removal of his belt and his
Why is
shoelaces.
he lawfully in custody?
He was lawfully in custody because he was lawfully arrested on probable cause to believe that he had committed disorderly conduct, with probable cause to believe that he was 16 years old. And he was brought to the precinct under that understanding.
And they know he's 15. Why are they holding him?
Well, for one thing, at that point, all that the officers really knew was that he had lied at one point about his age. He had first stated that he was 16, and then he had stated that he was 15. At that point, the respondent still didn't have any identification, and he still had not provided the officers with a phone number.
They had provided a way by which they could contact his mother, correct?
He stated that that his mother's phone number was in his phone, but the phone was not charged.
They did reach the mother.
Eventually, they reached the mother.
Through that number on the phone?
The number was on the phone, but at the time that they were lodging him into the juvenile room, they did not have the number yet.
But if they didn't think he was 15, why are they sending him to the juvenile room? It must be that they think this is his actual age.
Well, they think they have, they at this point don't know what his actual age is, and so they elected to proceed cautiously and to protect his rights as much as possible by placing him in the juvenile room. But objectively, they still have as much reason to believe that he is 16 as they do that he is 15.
Ms. Sadria, I believe the appellate division found that, I believe their words were that the police had no reason to believe Jamal was over 15. And in the trial record, the police officer testified that he was told the young man was 15, and he put him in the juvenile room. How does the finding of the appellate division and that trial record allow, what impact does it have on us?
I think the evidence in the trial record is that he stated first that he was 16, and he was arrested on that basis. And then after, some 20 minutes after arriving at the precinct, he said that he was 15. So they elected to treat him as if he was 15, but they still had reason to believe that he was 16. He had created a difficulty because he had stated, he had lied about his age at some point, but they, at that point, did not have an objective basis for believing either that he was, for crediting the statement that he was 15 over that he was 16. And so they elected to proceed cautiously. They put him in the juvenile room, and they tried to find out. They charged his phone and tried to reach in the effort to try to reach a parent.
Did they tell his mother eventually, don't come down? Don't come to the precinct, excuse me.
Right. He did not, the officer was not able to reach the mother until after, reach the mother until after the gun had been discovered. And at that point, arrest processing for possession of a weapon often takes quite some time. And so they told the mother not to come in until Officer Leo told the mother not to come in until later, because he knew that he was not going to be able to release him immediately.
It seems procedurally that this was proceeded as a temporary detention, not an arrest detention initially, when the search of the shoe took place. So if we rule in your favor, are we saying that there needs to be a full search of every juvenile temporarily detained?
Well, there needs...
In other words, okay, the shoe, well, I can see the shoe in a frisk, but what about a strip search? What about a more comprehensive search? Where does it lead?
I don't think that tapping out shoes leads to a strip search. I think a search, as a search incident to arrest, the police are authorized to conduct a full search of the person. That this court has not held that that necessarily includes a strip search, and certainly not for a violation. But even if this was not, even if this was just considered a detention, it is a reasonable measure as an administrative search for security reasons.
Administrative searches, I believe, well, in other custody settings, they do allow searches of shoes in administrative searches. Is that correct?
I believe that that is correct. And just looking at as an administrative search, the question is whether the balancing of the government interest in the search outweighs the privacy interest of the individual.
What is an administrative search, and what's the standard?
An administrative search is a search that is not an investigative search. It's not a search that is designed to uncover evidence of crime. It is conducted for some other reason. In this case...
For example?
Well, for instance, I mean, an inventory search is not a investigative search. It's an administrative search that's conducted for other reasons. This particular search was conducted to protect the safety of the detainee and to protect the safety of the precinct as a whole. And it was...
Can anyone be, if I walked into the precinct, could I be subject to an administrative search under one of the reasons that you say are various reasons?
Presumably, if you are walking into a police precinct voluntarily, you are not in custody. And the...
I understand that.
Right, but the interests are different. When there is a person, when somebody is in custody, in police custody, the police have a responsibility towards that person to ensure that he does not harm himself and to ensure generally the safety of the precinct against people that they are holding. And there is also a difference in your privacy interest. As this court has articulated it, taking somebody into custody is the greater seizure. A search that is incident to being in custody is permissible because it is a lesser seizure.
Thank you. Thank you, counsel.
May I just ask
Yes.
one more question? When they're on the street,
Yes.
and the initial stop, when he's talking to the defendant says, when he asks him, he says 16, but before he actually takes him to the precinct, if the defendant then says, I'm 15, could he take him to the precinct anyway? Under your theory, you're saying he's got reasonable cause to believe he's 16 because he has lied. Could he do that at that point?
You mean if he never said that he was 16?
No. He says he's 16, but he doesn't take the amount of time you're referring to, that is between the interaction on the street when he first says he's 16 and about 15 minutes at the precinct, he then says, well, I'm 15. If he had said that before he gets to the precinct, before they even put him in the police car, he says, no, I'm 15.
Right.
Under your theory, can't they take him anyway because they're not sure? And they have enough reason to believe he's really 16?
It's difficult to say in that scenario whether or not it would be reasonable to credit one or the other. I mean, it could be that they would have
Make a difference if it's
reasonable...
on the street or at the precinct? Why does it matter?
I mean, the only... Well, I think that it could be that the police officer would have reason to believe that he was 16 if he said that he was 16. And he has no identification, and he has no way, there is no way at that point of contacting a parent or somebody else who can confirm what his age is. It is possible that there could be circumstances where it would not be reasonable,
Thank you.
but...
Thank you,
depends on
counsel.
this record. Thank you.
Thank you. Counsel?
May it please the Court, Raymond Rogers for the respondent. I want to begin by briefly discussing the jurisdictional issue in this case, which is, this case is here by way of a notice of appeal on the two-justice dissent, which must be on an issue of law here. The issues in the case are the reasonableness of the police search, whether it was proper search incident to arrest, protective search. This Court has held repeatedly that those are all mixed questions of law and fact. So we believe the case should be dismissed on the ground it's not properly before the Court. But even if the case is here, that goes to the appealability of the case. The reviewability, and I think the Chief Judge was getting to that in the question. These are mixed questions of law and fact. It's a very limited scope
Let's
of review.
get to that issue on the facts. The timeline here. There's a statement on 16. They come to the precinct. I think it's fairly clear from the record that 20 minutes later, he says, no, I'm 15. I don't have the number for my mother. It's in my phone. My phone needs to be charged. Is it clear in the record that it's while the phone is charging that the gun is discovered?
It's not clear exactly when the gun is discovered, just as it's not clear exactly when the phone call is made to the mother. The police officer actually gives approximately 3 different times, 11, 11:30, and midnight.
But does he give the times, I'm asking, does he give the times in relation to what else is happening rather than a specific time?
There's, the only other time I think is referred to is about 20 minutes after he's there,
Right.
Jamal says that he's 15.
Right.
But the finding of fact, which I think if there's record support for that, is that the appellate division said the police then treated him as a juvenile, as if he was 15, and had no reason to think he was older than 15. There is record support for that here, and this court has very limited scope of review beyond that. It's only to look to see...
But what if
is there-
they're treating him as 15 in an excess of caution?
That's probably what they should do.
Right.
Is treat him as he's 15 in excess of
They're not
caution.
assuming they're saying, okay, we'll treat you like you're 15, we don't know.
Right.
And they could have thrown him in an adult holding facility, but instead, they put him in a juvenile waiting area.
Right. But at the time that he's 15, which is the holding of the appellate division, they have no grounds for holding him.
But don't they both, the majority and the dissent both say it's a question of whether or not it's a safety measure or not?
There is discussion of the safety measure, but the majority says when they...
But they don't disagree on the facts, is my point. The majority and the dissent take the facts as they are, and then they make a legal determination on that. And the majority, as I understand it, said, there was no reason to ask him to remove his shoes as a safety measure, and the dissent says, yes, there is, right?
That's a later point. But the earlier point, the majority holds that once the police determined he was 15, they had no grounds to hold him whatsoever, no grounds to put him in that juvenile room. Because the only grounds they have him down there for are either disorderly conduct, a violation, or a traffic infraction, neither of which a juvenile can be taken into
So
custody.
your entire case rests on they never should have taken him to the precinct.
No, well, we don't think this is a narrow case involving just the last shoe search that took place. We do think this is a street encounter, you look from the very beginning of it until the very end. And under Victor M., this court's precedent, it's clear that when he didn't have ID, and the police were always only going to write a summons. This was never a full custodial arrest. That's an important distinction. Judge Fahey said it was a temporary detention. That's all it ever was. In Victor M., the court said, when you have a teenager, and in that case they were going to write a summons for gambling, you have a teenager who doesn't have identification but lives nearby, and my client had given the police his...
That was a teenager. And Victor M. actually says Victor was 15 years old at the time of his arrest, and there is no evidence in the record that the officer either believed or had reason to believe that he was older. Isn't that very different?
No, I don't think so, because they say it was unreasonable to take Victor to the precinct.
Because they knew he was 15.
No, rather than take him home to get his identification, to write the summons.
Right, because they had no reason to believe he wasn't 15. Here, your client said, I'm 16.
That's a different part of the holding in Victor M. There were 2 or 3 holdings, and the one part about where to take him, it's very clear. The court said it wasn't
But
reasonable.
I want to get back, you're saying they should not have taken him to the precinct.
That's right.
They had no reason to. He said he was 16. They should not have believed that. They should have said, you're 15, and we're letting you go as much as you want to say you're 16.
No, we're saying if they wanted to write a summons,
I know, but my point is
they should have
that,
taken him home.
my point is that if he says he's 16, they take him into custody. Is that nothing wrong with that, right?
Well, they cannot, they possibly could have, but they did not make a full custodial arrest here. They took him to the precinct only to issue the summons. So he's never...
But because they could, because he was 16 as far as they were concerned. He then says he's 15, and
Yes.
they take him to this room. What I wanted to focus on was what I thought would the thing was, where the majority says this is not a safety measure, that they should have let him keep his shoes on, which meant he therefore could have kept his weapon. And I just don't see that. I would think that if you're going to put him someplace, you ought to make sure he doesn't have a gun that he can shoot somebody with, or himself, for that matter.
Well, it's once again, I think it's very important to focus on the fact that there's only a temporary detention, not a full custodial
Let's
arrest.
staying on that for a second. And Judge Piggott's point, the interesting part about that is, let's say, forget about the gun. No one could contest that they could take his shoelaces or his belt in the temporary detention. So wouldn't you check for a gun?
Well, we don't think he should have been detained in the juvenile room.
No, I understand that, but let's talk about the frisk itself or the search itself. A search and a temporary detention, because it seems to me to be boiling down to that. I think it is a temporary detention. So what's proper in that situation? That's what we're talking about here. So the safety issue then becomes absolutely relevant. So if you can take somebody's shoelaces, somebody's belt to protect them, you can't tell them to bang their shoes on the floor and to make sure there's nothing there that could hurt themselves with it?
I don't think there are any grounds here when you look at the law, even for a search incident to arrest, under this court's recent precedent, Jimenez with Goki, a search incident to arrest.
Not to interrupt you, but looking at the majority, and maybe you can get me off this, but it said the removal of Jamal's shoes cannot be justified as a protective measure. It said the dissent's suggestion that the search conducted here was necessary to prevent Jamal from shooting himself or a police officer was unsupported by the record.
It was additionally intrusive to have him take his shoes off. He'd already been frisked 3 times, and both officers...
Well, that's my point. You agree with them that they should not have told him to take off his shoes.
That's correct.
All right, and even though we now know that he had a gun.
Well, we don't look at the results of the search, Your Honor.
Well, we do to the extent that if they say we're doing it for safety, and you say, well, it's not for safety, it's not. They just shouldn't have done it. I don't get it. I mean, they obviously wanted to do it for safety. That's what they always do, as Judge Fay is saying. That's why the belt goes. That's why.
Right, but this court has limited even safety searches. Strip searches, for example. This court has said there must be reasonable suspicion that the individual is concealing contraband. In this case, both police officers testified they had no reason to suspect my client was concealing anything.
Okay, so are we then looking at what the reasonableness of the search under, or of the issue under the circumstances of this particular case? And if so, why isn't this a mixed question?
Well, I think it is, everything in here is a mixed question of law and fact, and the question is there record support for that? And I believe there is. Here, that the police had no suspicion.
But it wasn't the same officer who had done the pat-down, and it was...
And he testified he had no reason to suspect that this individual was armed in any way. He was fully cooperative from the very beginning. There was no justification for the initial frisk.
You're arguing that we should write a decision that says if you detain a juvenile, whether it justifiably or not, don't search him.
No, we're saying you need reasonable suspicion.
Right, don't search them.
No,
There's
you
no
need-
reason to suspect somebody may hang themselves or use their shoelaces. Leave that alone. And by the way, don't search his pockets and don't look for weapons because he's a juvenile.
He's not being put into a detention facility.
Right.
That's the important difference.
Right,
This
so
is not an
don't touch
individual.
him. Right?
Pardon?
So don't touch him.
That's correct. Do not search him. He's only being temporarily detained. You have no reasonable suspicion to search him for anything.
No, they don't. It's not. They don't want to do that. They want to make sure he's safe.
Right, and they could keep an eye on him. They never even had to bring him to the precinct in the first place. And in Victor
I know,
M,
but we're already there. I guess
Victor
that's where
M, this court said you shouldn't.
I'm going to concede for you. I'm going to say you want to talk about before they got to the precinct. I want to talk about after they
I'm
got
okay at the precinct too, though. And I think even if it's an adult, when you have a temporary detention of an adult, let's say they take an adult in for a traffic infraction because the adult doesn't have ID. In that situation, unless you have reasonable suspicion, you shouldn't be searching the adult either.
Let's assume they impound a car. Can they search it?
You impound the car. Well, you might, for a car, you can do an inventory search, sure.
Exactly. And so.
But he's not being incarcerated. My client is not being put into jail. If he's being booked and put through the system, you can do an inventory search. You can do a jail processing search.
I don't mean to be facetious, but I'm just wondering, if he walks in with holsters and 2 guns on him, and you just put him in detention.
Well, that's it. He didn't walk in with holsters and 2 guns on him, Your
But if
Honor.
he did.
So can I just, I'm
But if
sorry.
he did.
I'm sorry.
Then we have reasonable suspicion to search him.
Okay, never mind.
But you have no, the police officers testified they had no suspicion whatsoever. He was fully cooperative. It's a bicycle infraction. Remember, he's down there.
But you concede that they can ask him to take off his belt and his shoelaces, right? So
Well, I
isn't
don't
it-
really concede that, no.
You don't concede that?
No.
Okay, all right.
But if I'm understanding your argument is, there's a mixed question of law and fact as to whether or not they believed that he was 15 and treated him thusly, and you're arguing there's enough record support for the appellate department's decision on that, and that determination about whether or not to remove the shoes is again based on whether there's reasonable suspicion, and the appellate department could have concluded there isn't based on the record, and that those are all those mixed questions of law and fact, and we're stuck with the factual determinations, or we're bound by them. My understanding,
That's
this
excellent.
part of that mixed question
That was an
of law and
excellent
fact
job of
argument-
summarizing my argument.
I just want to
I'll
make sure I
stand
got
on
it
that.
right, because...
That's it. I'll stand on that.
Thank you, counsel. Counsel?
As to the...
Why isn't that summary right? I mean, that's his argument, but the question is, why isn't he correct about that?
Because we're not arguing that there was reasonable suspicion. What we are arguing is that the police officers did not need reasonable suspicion, because whether this is viewed as a search incident to arrest or whether it is viewed as an administrative safety search, in neither case was reasonable suspicion necessary. I mean, so it's a clean legal argument.
Well, is that, but the administrative search, you've already conceded, is not the equivalent of other full searches, like the strip search or some other more, as you had actually referred to them, more intrusive searches. So isn't that dependent on the reasonableness of the concern regarding the suspicion of whether or not this person poses a safety risk to
Well-
himself or anyone else?
Actually, I'm not saying that, I'm not, an administrative search, the whole distinction between an administrative search and an investigatory search is that reasonable suspicion and probable cause are not part of the equation, because the purpose is not to uncover evidence of crime. You're
saying it's a lower
there's a different
or higher
purpose.
threshold?
In this case, the purpose was to ensure the safety of the detainee and ensure the safety of others in the precinct by making sure that the respondent did not have readily accessible weapons. And so the test for constitutionality is whether balancing the government interest...
Let me ask this. If they thought, since you say they have reasonable suspicion to think he's 16, if they thought he was 16, they believed his initial statement, is it still an administrative search?
Well, it is a search incident to arrest, and so, I mean, there's established precedent that a search incident to arrest requires no further justification. But part of the reason for...
I'm not really understanding the difference in the standard. You're kind of having it both ways, are you not? Whether it's an administrative search or this other search, an incident to an arrest, they get to do the full-blown check of him.
The only difference between whether he's 16 and, I mean, the only difference at all is whether or not he should be considered still under arrest, and so the search should be considered incident to arrest, or if it is just a search of a detainee for an administrative purpose. And the only reason that makes a difference is because there's a great deal of case law stating that a search incident to arrest requires no further justification. With a search that is an administrative search that is not incident to arrest, you have to balance the factors, you have to examine how whether it is done, it's reasonable in its scope, it's related to its purpose, it's
And
done
is
to
any of that a
establish
mixed
procedure.
question of law and fact?
No, it is not a mixed question of law and fact.
Thank you, Ms. Adria.